Hi, and welcome back to another series of Read Me. Today we shall look at the Criminal Procedure Code. We'll start off with part 2 of the Act, which is powers of courts. Now, the Criminal Procedure Code is the act that describes how criminal trials are conducted in the Kenyan courts, and it provides all these conditions of arrest, how arrests are going to be made, by whom, issuance of summons, and so many other interesting topics. So today we look at powers of courts, and under this part of the Act, it talks about the jurisdiction of the courts, the criminal courts in Kenya, and we have the structure of the courts. That is the beginning point. So the highest court in Kenya is the Supreme Court, and that is followed by the Court of Appeal, and then the High Court, and then the subordinate courts. Now, under most of the criminal trials in Kenya are conducted by the subordinate courts. The High Court has jurisdiction under this part of the Act to hear many matters and offer many sentences, okay, as allowed by the law or by this code. And the subordinate courts are the courts are classified into the magistrate courts as well as the subordinate courts of class 1, class 2, and class 3. Now, under the magistrates courts, we have the district magistrates courts. These ones are of class 1, 2, and 3, and the under section 7 of the Criminal Procedure Code, it outlines the jurisdiction of the district magistrate class 1 courts as being those that can impose imprisonment for a term not more than 7 years. So the the first class courts will only be able to give sentences that do not exceed 7 years, and they will be able only to give a fine not exceeding 20,000 Kenya shillings. That is followed by the magistrate courts of the second class, giving, that is the DM2, the district magistrate court 2 has the jurisdiction to offer cases, to offer imprisonment for a term not exceeding 2 years, or a fine not exceeding 10,000 shillings. So jurisdiction is is either territorial based on the geographical limits of the particular locality, or pecuniary. In this case, we have the issuance of fines that do not exceed a certain amount. For the DM1, DM means district magistrate, court 1 will offer only those of 7 years. Just a minute. 7 years, or a fine of not more than 20,000 shillings. So another type of jurisdiction is jurisdictional, meaning whatever the act or this code outlines certain offenses to be triable at a particular court, that is what will happen. Okay, it gives the jurisdiction of that particular matter to be heard in that particular court. For example, we have the resident magistrate court has the same powers generally as the district magistrate court, being a court of first class, but it has it's been given extra matters or jurisdiction of matters pertaining to Sexual Offences Act, as well as matters of handling stolen goods under Section 322 of this code, and matters of preparation to commit a felony, being when somebody is being found in possession of a weapon, and that is under Section 308, subsection 1 of this code, and the last one being the stealing of stock under Section 278, stock being livestock. So the resident magistrate has these powers that are jurisdictional, meaning specifically given by an act of parliament or by any written law that is in effect in Kenya. Now, once we've looked at that, we can just move on to note that the Judicial Service Commission, which is in charge of hiring and firing judges, has the discretion to extend the jurisdiction of subordinate courts, and this can be done by notice in the Kenya Gazette. Okay, they can extend the jurisdiction of a particular magistrate. Yeah. Now, moving on to sentences. Section 14 is talking about sentences which have several offenses. Okay, those sentences can be joined together such that the person either gets a lump sum sentence to serve, or consecutively or concurrently as the court may direct. Concurrently, I believe, means that if, for example, the offense of stealing livestock attracts a maximum sentence of 14 years, and that of stealing a motor vehicle is 7 years. So you can concurrently would mean that they run simultaneously, okay, and consecutively they run one after the other. So let's move on to suspended sentences. These are sentences which are they have an operational period, meaning that if one is given a suspended sentence, it will not take effect unless during a specific time where that offender commits another offense. So it's kind of conditional. Okay, I think there's also one called conditional sentence, but I don't want to go there. So a suspended sentence it has an operational period. It's like it requires a catalyst, and that catalyst is the commission of another offense, okay, which is punishable by imprisonment, corporal punishment, or a fine. So once a person commits another offense, the previous sentence, the suspended sentence in relation to the previous offense will take effect, okay. All right, so we have what we call combination of sentences under Section 12. Any court can pass a lawful sentence combining any of the sentences which it is authorized to pass. On that note, when we talk of sentences relating to several offenses in one trial, like I gave a previous example of stealing livestock and a motor vehicle at the same time, there's a condition here which requires that, except in cases to which Section 7.1 applies, which 7.1 we saw was the sections I said relating to stealing of livestock, handling of stolen goods, and preparation to commit felony. Nothing in this section shall authorize a subordinate court to pass on any person at one trial consecutive sentences of imprisonment which amount in the aggregate to more than 14 years, or twice the amount of imprisonment which the court, in the exercise of its jurisdiction, is competent to impose. So when it comes to concurrent consecutive sentences, where those sentences follow one another, you serve the first part and then you continue with the rest. Okay, this is limited as far as subordinate courts are concerned because of jurisdiction. So no subordinate court can pass a sentence that is that is twice its jurisdiction allows. Okay, and also it cannot pass a sentence where imprisonment is more than 14 years. Okay, in totality, like when two offenses, if you combine both sentences, will add up to 14 years. But remember, when it comes to stealing livestock, which is a serious offense, by the way, in Kenya, surprisingly, which attracts a maximum penalty of 14 years, that is an exemption. So the offenses that I've listed, such as handling goods, which I think handling stolen goods, and preparation of a felony, which I think attracts a maximum of 15 years, if I'm not wrong, those are exceptions, because a resident magistrate is a subordinate court and they have this extra jurisdiction to hear those matters. So in this case, they can give consecutive sentences in relation to those offenses which I have mentioned. But other than that, a subordinate court is not allowed to give a sentence that actually goes more than its jurisdiction allows, as well as more than 14 years as a consecutive sentence. Or this also applies in relation to fines, that a subordinate court cannot impose fines that in total more than twice the amount that they are supposed that they are competent or their jurisdiction allows them to give. All right. Now, for the purpose of appeal, any consecutive sentence given in a trial shall be deemed to be a single sentence. Yeah, this one I already said. When it comes to consecutive sentences, the sentences run one after the other. Okay. And when it comes to suspended sentences, I say suspended sentences are operational. They only when you commit another offense during a specific time or during that time of the sentence. And when that happens, the first it's like a catalyst. The subsequent offense is a catalyst for the previous offense. In this case, what happens? Are you forgiven for the subsequent offense? No, you serve the first sentence, and once it's done, you consecutively the sentence for the subsequent runs after that. You serve it after, so you like serve twice. It's not like bygones are bygones kind of situation. So the next part of this act is part 3, which has general provisions regarding arrest. Generally, what we should know about arrest are that a person, a civilian, you and me, we can arrest someone. All right, a magistrate can arrest someone, a police officer can arrest someone. So Those are the people who can arrest others, arrest criminals during commission of an offense if it happens in their presence. In making an arrest, the police officer or other person shall actually touch or confine the body of the person to be arrested, unless there be a submission to custody by word or action. So unless somebody submits themselves, there is that contact between the arrested and the person who is effecting the arrest. This can be through touch or confining the body of the person, okay? If a person resists the attempt to arrest him, okay, or attempts to run away from the arrest, the police officer or other person may use all necessary means to effect the arrest. That is why it is advisable not to run. If you find yourself getting arrested, there's no point resisting, refusing to have the handcuffs being put on you, or to run away, because this only aggravates the charges that are against you. It's better you just relax and just get a nice lawyer to help you. Nothing in this section shall justify the use of greater force than was reasonable. So also, on the other hand, the person who is effecting the arrest should not use any unreasonable force. Okay. That is section 21. Now, section 22 of the code says that search of place entered by person sought to be arrested. So, any person acting under a warrant of arrest or any officer, police officer, has reason, if they have reason to believe that a person has entered into maybe a house or a building, residing or being in charge of that place on demand of the person, okay, allow him free ingress. So entrance, you are allowed to enter a building or house where, as an officer or a person effecting the arrest, as an officer with a warrant of arrest, okay, you suspect someone is hiding, okay, or is dwelling in that place. If it's their house, of course there is a way you can break in, as we see in the movies, where you on certain conditions and affect the arrest. If you suspect they are running on the other side or through the back door, something like that. So we'll go to that. But any person who owns that building or whose house that is supposed to allow the officer to enter freely to affect the arrest or to search for that person he suspects to have been there. If ingress to a place cannot be obtained under this subsection, it shall be lawful for a person acting under a warrant, and in any case in which a warrant may issue but cannot be obtained without affording the person to be arrested an opportunity to escape, the police officer can enter that place and search, and in order to get that entrance can break open any outer or inner door or window of a house or place, whether that be of the person to be arrested or of another person. Okay, so this is what I said. You need a warrant to break into a house or a building or a place that you suspect the person is hiding, but you are allowed to break into without the warrant. But the warrant is issuable, except that you don't have it now. Maybe the magistrate or judge hasn't yet signed it. So you're allowed to break in if you hear or see evidence of the person trying to escape. Okay. All right, so there's a very peculiar provision under section 22 of the code which exempts the breaking in of an officer just like that, where the person who is in who is occupying the house, okay, is a woman who is not supposed to be seen by the, okay, according to cultural customs. So the officer will need to ask the woman first to withdraw or get out of the house before he can break in. Now, section 23, power to break out of house for purposes of liberation. A police officer or other person authorized to make an arrest may break out of any house or place in order to liberate himself, okay, or any other person who was trying to make the arrest, or any other person who is detained in that place that the officer effected the arrest. So no, section 24, no unnecessary restraint. The person arrested shall not be subjected to more restraint than is necessary. This makes sense. We said no unreasonable use of unreasonable force, as well as in this case, no unnecessary restraint. Section 25 of the code, search of arrested persons. We have whenever a person is arrested by a police officer under a warrant which does not provide for the taking of bail, or under a warrant which provides for the taking of bail, but the person arrested cannot furnish bail, or without warrant, okay, or by a private person under a warrant and the person arrested cannot legally be admitted to bail or is unable to furnish bail, the police making the arrest, okay, or the private person making the arrest, okay, they can search that person and place in safe custody all things other than necessary wearing apparel found upon him. Okay, I don't get this, but I think a police officer is supposed to search the person's being, and if they find anything on them, they submit the same. Okay, and the condition is that the person is arresting under a warrant which does not provide for bail. Okay, for example, those offenses which are not bailable, like I think treason, if I'm not wrong. So another condition is that the person arrested without warrant cannot legally be admitted to bail or cannot furnish bail. Okay, moving on to section 26, power to detain and search aircraft, vessels, vehicles, and persons. A police officer or authorized person in writing in that behalf by Inspector General of the National Police Service may stop, search, and detain an airplane. Okay, vessel. A vessel is a ship, a vehicle, a car, in or upon which there is reason to suspect that anything stolen or unlawfully obtained may be found. So imagine having the power to stop an airplane with all the passengers, okay, in waiting to take off. So this can only be done by the permission, okay, in writing of the Inspector General of Police. Okay, any aircraft, vessel, or vehicle which there is reason to suspect has been used or employed in the commission of a crime or an offense under the provisions of Chapter 26, 28, and 29 of the Penal Code. Okay, yeah, so these offenses must be really big for this to happen. I don't have the penal code with me now, but we'll look at this later. Which type of offenses those are? Any person who may be reasonably suspected of having in his possession or conveying in any manner anything stolen or unlawfully obtained. No, so it's not only just aircraft, vessels, and okay, let me not say vessel, aircrafts, ships, boats, cars. It's also people. They can be stopped, uh, detained, or searched. Okay. No person shall be entitled to damages for the loss suffered by him in respect of the detention under this section. All right, so if any damage were to occur to the airplane, car, ship, boat, no person is entitled. The owner is not entitled. The company is not entitled to any compensation. For the purposes of this section, aircraft, vessel, and vehicle include everything contained in, being on, or attached to these things, okay, which forms part of the equipment. All right, so mode of searching women, that is under section 27. Whenever it is necessary to cause a woman to be searched, the search shall be made, of course, by another female officer with strict regard to decency. So they cannot fondle you, even if they are a woman, because we know that sexual assault can also happen woman to woman. Yes, it can. Yeah, in this world, it can happen. So section 28, power to seize offensive weapons. The officer or other person making an arrest may take from the person arrested any offensive weapons, all right, which he has about his body, and shall deliver all weapons to court as evidence. All right, so if found with a weapon, we already know first that is an offense, because it's like a preparation of commission of a felony under section, what was it? Gosh, my memory. Section two, not two, sorry, 308. Yeah, section 308. Now, moving on, arrest without warrant. Under section 29, it outlines the conditions or circumstances where an arrest can be made without warrant. Arrest by police officer without warrant. So in these situations, a police officer may arrest someone without an order from a magistrate or without a warrant of arrest. Any person the police suspects upon reasonable grounds of having committed a cognizable offense. Now, a cognizable offense is an offense which you can arrest the person who committed without a warrant. So, if a police suspects you of committing an offense that is cognizable, he will arrest you without requiring a magistrate to give that order or that piece of paper called a warrant. Any person who commits a breach of the peace in his presence. So be very wary when you are in the company of a police officer, because, for example, if a police were to go and witness in his presence a fight ongoing, any disruption of peace in going on, or robbery in his presence or anything like that, all these things, they allow him to just simply arrest you without any question, without consulting anybody, without asking the magistrate or getting the warrant. Okay, so he won't go and then you see him later. He'll just effect the arrest right there and then. Any person who obstructs a police officer while in the execution of his duty. So if a police officer is trying to investigate or arrest you, and somebody close by tries to prevent that, maybe by holding on to you, if it's a family member, don't go there, or trying to hide you somewhere, or make you escape, that is getting in the way of the police officer, obstructing justice, you know Yeah, so any person in whose possession anything is found which may reasonably be suspected to be stolen property. So where maybe someone, like in the videos we see, has reported stolen property to the police, and if it's a car with the license plate and the officer spots that car, okay, with someone else, they are going to arrest you without warrant. Any person whom he suspects upon reasonable grounds of being a deserter from the armed forces. So, yes, this I've also seen in a movie where someone deserts the armed forces and runs away for any particular reason from service. All right. This person can be arrested without warrant. Any person whom he finds in a highway, yard, or other place during the night and whom he suspects upon reasonable grounds of having committed or being about to commit a felony. So this person who is just taking a walk in the middle of the night, okay, this is really risky because you can be arrested for no particular reason if found in the wee hours of the night somewhere you are not supposed to be, like a highway, a yard, or any other place. All right. Any person whom he finds in a street or public place during the hours of darkness. All right. So this also includes streets and public place during the hours of darkness, and whom he suspects upon reasonable grounds of being there for an illegal or disorderly purpose, and who is unable to give a satisfactory account of himself. This includes going to Uhuru Park, for example, being a public park, after and being found there past 6 p.m. I remember there was a time I almost got arrested for being there. It was still not dark, but yeah, the police officer was coming on to me like, why are you here? It was just a little after, I think, 5 something, and they are already, everyone was running for their lives from that park, including the vendors and the hawkers. It was crazy. So please don't be uh, in those places, because a police officer can say that they suspected you were there for an illegal purpose. What can you say to defend yourself? Any person whom he suspects. So this is actually an offense, and I'm glad I am seeing it here in the code, because it's not something you would normally know. Okay, there was no sign there that says you are supposed to leave the park after this time, so it's good to know. Now any person, another instance is where he suspects that he possesses where the person can answer to the offense of housebreaking. Okay, where you are found in somebody's house, where you enter without somebody's house without their permission, through the window, through the door. Any released convict committing a breach of any provision, okay, in this code. Any person for whom he has reasonable cause to believe a warrant of arrest has been issued. All right, so those are the circumstances where an officer can arrest you without warrant. Now we move on to section 30. We are almost done with this part. I hope so. Oh no. All right, so arrest of vagabonds, habitual robbers. An officer in charge of a police station may in the same manner arrest or cause to be arrested any person found trying to conceal his presence within the limits of the station. Okay. All right, that didn't make sense. Moving on to section 30, arrest. Oh, what is this? I'm repeating myself. All right. Yeah, that's just a repetition. Now, section 31, procedure when police officer deputes subordinates to arrest without warrant. When an officer in charge of a police station requires an officer subordinate to him to arrest without a warrant, any person who may lawfully be arrested without a warrant, he shall deliver to the officer required to make the arrest an order in writing, specifying the person to be arrested and the offense that he's being arrested for. That is self-explanatory. Section 32, refusal to give name and residence. When a person who is in the presence of an officer has committed or is being accused of committing an uncognizable offense, that is an offense that you cannot be arrested without a warrant for. If this person refuses on demand to give his name and residence, or gives a name or residence which the officer believes to be false, he may be arrested by the officer just so the officer can find can can get his name and residence. When the true name and residence of the person has been obtained, he shall be released on executing a bond. So he'll be released by bond to appear before a magistrate if required. Should the true name and residence of the person not be able to be gotten within 24 hours from the time of arrest, or should he fail to execute bond, he will be taken before the magistrate, before the nearest magistrate having jurisdiction. All right. Now, section 33, disposal of persons arrested. A police officer making an arrest without a warrant shall, without unnecessary delay and subject to the provisions of this code, as to take or send the person arrested before a magistrate having jurisdiction in the case, or before an officer in charge of a police station. So where a police officer effects an arrest without warrant, they should not dilly-dally in any way, shape, or manner. They will have to immediately take the person and bring them before a magistrate, okay, who has jurisdiction to hear that case. Or he will take them to the station before the officer in charge. Now, section 34, arrest by private person. I said one of the people who can arrest is me and you. So a private person may arrest any person who commits a cognizable offense. This is an offense you can arrest without warrant, or whom he reasonably suspects of having committed a felony. So it's not a misdemeanor, it's a felony. All right, persons found committing an offense involving injury to property may be arrested without a warrant by the owner of the property. So this makes a lot of sense, where someone destroys your car and you take them to the police station. So the action of taking is you're arresting them. Or if you don't do it yourself, then any person you authorize, you ask to do it on your behalf. Now, section 35, disposal of person arrested by private person. Now, what happens when you're arrested by your neighbor, for example? A private person arresting another person without a warrant shall, without unnecessary delay, make over the person so arrested to a police officer. So you rush the person you're arresting to the nearest station, or in the absence of a police officer shall take that person to the nearest police officer or to the nearest station. If there is reason to believe that the person comes under Section 29, a police officer shall arrest him. Section 29 was under the circumstances we mentioned, where a police can arrest without warrant, shall re-arrest him. So where the circumstance is falling under Section 29, where the police can arrest without warrant, then the police will re-arrest the person, because it's re-arresting because the person has already been previously arrested by the civilian. So if there is a reason to believe that he has committed an uncognizable offense and he refuses on demand to give his name and residence, or gives a false name or residence, he shall be dealt with under Section 32. That is what we say, where the person arrested refuses to give his name and residence, or gives a false name and residence. What happens is simple. The only thing is you take that person in custody. You take that person, do I say in custody? You arrest that person so that you can ascertain their name and their residence. And after you've done that, this person can just be left to go on his merry way, on bail. And if he can't do that, he can't he can't afford or furnish bail for any reason, you are supposed to bring them before the nearest magistrate. You can find. So that is Section 32. The same happens here. All right. If there's sufficient reason to believe that he has committed an offense, he shall at once be. If there's no sufficient reason, he will be released. So arresting, remember, is not just putting on handcuffs. It can also be confining that person. So once you arrest, you confine them pending arraignment before a magistrate in a court. So that is 24 hours, I think, if I'm not wrong, is the time, the only time you're allowed to confine this person before bringing them to the nearest magistrate. Now, remand by court. Pursuant to Article 49(1)(f) and (g) of the Constitution, a police officer shall present a person who has been arrested in court. Oh my God, excuse me. Within 24 hours after being arrested. This is just what I said. So where the police feels like they need more time, to have the person arrested, maybe they are trying to pursue evidence that will be sufficient to charge him or something, they will apply in court, in writing to the court, for an extension of time to have the suspect be put in custody, produce the suspect before a court. So there's no way that you can hold someone beyond 24 hours without having them being produced or appear before the court, before a magistrate, and to have your application for extension of time in writing. All right. An application, so this is a deviation, but if a police officer holds a person in custody before they are even charged, that is illegal confinement, which the person can be can apply for, if what do you call, they can apply for, was it the application of habeas corpus, if I'm not wrong. If I'm wrong, then I better read more. An application under subsection 2 shall be supported by an affidavit sworn by the police officer and shall specify the following: the nature of the offense for which the suspect has been arrested, okay? Excuse me, the general nature of the evidence on which the suspect has been arrested, the inquiries that have been made by the police in relation to the offense, the reasons why the person should be staying in custody before they are charged, should be staying more days or more time. So that is the application we talked about under section 36A, where the police feels that the person needs to be arrested, needs to stay longer, okay, in police custody before they are charged. Before they have, maybe, I don't know, but it's really interesting to see all these movies and series where they affect arrest of persons, but then the person is released because why? There's no sufficient reason, okay, to show that he committed an offense. So that's why police normally, before they arrest someone, especially if it's a high profile case, they make sure that they do their sting operations, they investigate, like they follow the person, keeping an eye, trying to get what do you call them, they trying to get permissions to go into their email, to know, to get grounds for sustaining that arrest, okay? Otherwise the person is going to be released, all right, if there's no sufficient reason. Now moving on determining an application under subsection 2, the court shall consider any objection that the suspect may have. So it's not just a one-way guaranteed application of extension of time to keep the suspect in custody, all right? The suspect is also uh, uh, the suspect is also uh, able to object, okay? They can object and give their reason for why they should not be for why the extension of time should not be granted. So the court shall consider any objection that the suspect may have in relation to the application and may release the suspect unconditionally. So the suspect can be released or release the suspect subject to such conditions as the court may impose to ensure that the suspect does not commit an offense during his release or interfere with witnesses or the investigations in relation to the offense for which he has been arrested. So now we see that where a suspect is released. For example, I'm thinking of a situation where the police requires the person maybe is a dangerous criminal. Like, okay, if he is left or released, he's going to be he's going to murder people, he's going to kill, if it's in the case of a serial killer, like in the case of, what was this movie I watched of a serial killer? Yeah, so in the case of What was this? I don't remember this series. Something just appeared on my... Let me just end this stream, okay? Let me just end. I'll be back shortly.